Good morning, everybody. Hope y'all are doing well this cold Texas winter day. Hopefully y'all are all staying warm and have started the new year off fairly well. So today we have got a lot of information to cover. Unfortunately, standard of care and volunteer immunity can be a little bit of a difficult task in terms of education and understanding, but hopefully we can do some guiding throughout this series. So my name's Clint Brown. I am, of course, with the law firm Roberts, Markell, Weinberg, Butler, Haley. I'm an equity shareholder with the firm, and I lead our Property Owners Association division. So welcome to this education series. We're going to be talking today about standard of care and volunteer immunity for property owners associations. So as you probably know, a POA is a term of art that includes both single family communities, townhome communities, and condominium communities, whether they're regime, high rise, mid rise, low rise, or one of those unique condominiums where you drive in and it looks like a single family community. So this presentation and the term of art POA covers all of that. One quick reminder before we get started, this presentation gives you education credit. So it is CE approved. If you need that education credit, you should have notified us upon registration. If you didn't notify us upon registration, please feel free to just reach out to our law firm and we can get that education credit to your attention. Please also note that we get a lot of education credit requests. So you should see your certificate about a week after today. So expect to see that next Wednesday. Sorry for a little bit of that delay, but we've got to process it and all that other good stuff. With that, let's get started. So our goals for today, and I'm sorry, one more comment. If you called in rather than register and you need that credit, please email us and we can get you credited with your name and good contact information. So our goals here for today, we're going to be talking and looking at the application of the review standards for how courts look at you as a board member or a committee member, if some of you are committee members that are on the call here today. And there are two standards of care that we really look to, and one is the reasonableness standard. The other one is what is called the business judgment rule or the business judgment standard. And we're also going to be asking the question, do board members have a fiduciary duty? And if they do, who is it owed to? Is it owed to the members? Is it owed to the association? And finally, when is immunity from suit available to volunteers? That qualified immunity bubble that protects you as a board member or officer or other volunteer, which may include committee member. So let's get into kind of the concept of charitable immunity, how it arose here in America and developed, and then was abolished for a short time by the courts, and then it was readopted statutorily, both on the state level and on the federal level. So charitable immunities development in common law, basically there are four theories of how charitable immunity came to be. The first theory is kind of called a trust fund theory. So you think of requesting services from a charitable immunity or from a charitable organization, or giving money to a charitable organization. Once you do that, you've kind of put it into a trust and it's gone. So you really can't come after the trustee once you've given the funds over. That's the trust fund theory in a nutshell. The waiver theory is that, look, when you come in and you get services from a nonprofit or charitable organization, you have at least implicitly waived any kind of rights to go after them down the road because you knew you are dealing with a charity. So an organization that takes money in, and the same money that goes in is the same money that goes out. That's another theory and why charitable immunity came to being, because basically, this is a company you're dealing with that's not in it to make money. Another theory that allowed for charitable immunity to develop is what's called the respondeat superior theory. Of course, attorneys like their legal jargon and Latin phrases. This basically is the idea that an employer should be responsible for the actions or failure to act of its employees. And the courts basically indicated that theory, respondeat superior, which is kind of like negligent hiring almost, should not apply to charitable organizations. And then finally, public policy theory, just looking at it from a public policy perspective, they want to encourage charitable organizations to do work in the nation. And because of that, they feel like it was a sound public policy to grant those organizations some form of immunity. It was created in Massachusetts in 1876, and then Maryland and others kind of followed suit in 1885. All right, so abolishment. In 1942, a federal court decision more or less began the end of charitable immunity. They decided not to use any of those theories of recovery and held the charitable organization to normal business standards of care and liability. By 1984, a majority of the states had followed that federal court reasoning and in one way or another abolished charitable immunity. So we're dealing with mid-80s, big issue with charitable organizations and some other national issues and concerns that kind of arose in the 70s and early 80s as well. One of the biggest one is that women really started going into the workforce in the 70s and 80s strongly. And because women were entering the job market, there was less volunteers available to really run these charitable organizations and help contribute to the country's charities. That with an ever increasing fear of personal liability. So you have persons that were volunteering. They're either working and volunteering or not working and volunteering. They just saw this personal liability potential increasing with the increase in lawsuits. Why? Because common law charitable immunity had been abolished. And that fear basically, hey, I'm just not going to put myself out there. I don't need to be personally liable for being a volunteer for this charity. So President George H.W. Bush identifies this issue as a nationwide crisis. So volunteerism dropped significantly because of all these issues, the abolishment, the women entering the workforce, and that fear of personal liability. And so basically by 1986, most states enacted in response to those issues some form of legislative protection that offered this qualified immunity bubble that we're going to be discussing here in a little bit. And then finally, by 1997, the U.S. legislature acts by adopting the Federal Volunteer Protection Act. So, concept of charitable immunity. Let's get into it a little bit here. Here is our general standard of care in the state of Texas. So for community associations, we are governed by Chapter 22 of the Texas Business Organizations Code. That is the Nonprofit Corporation Act, is Chapter 22. It governs all community associations here in the state of Texas. And it basically provides for a very general standard of care. It requires board members, unless there's another act that provides for a stricter standard, which we'll be discussing. It generally provides that all directors shall discharge his or her duties in good faith, with ordinary care, in a manner the director reasonably believes to be in the best interest of the community. So good faith, ordinary care, reasonableness. Well, of course, all three of those terms are very subjective. So how do we really define that? I like to use the grocery store example. Those of you who have heard this webinar before with me are probably familiar with it, but you walk into a grocery store, you go into your produce department, maintain that 6 feet of distance, make sure you have your mask on, right? And you ask somebody, hey, if you lived in a community association and your board was about to do X, Y, and Z, how would you respond? Does that sound reasonable to you? And if the person looks at you and responds with, yeah, that sounds about right. I'm in an association. I've given up certain rights, and it sounds like the board could probably do that. Well, then you've met your standard of care. So it is a reasonableness standard. Now, if they look at you like you're crazy, start laughing, or their jaw drops, maybe that decision is something that you want to revisit and work with your management company on, and or legal counsel or other expert to figure out whether or not it's a good one. So again, directors are not liable for their actions if they've met that standard. Good faith, ordinary care in a manner they reasonably believe to be in the best interest of the community. So if you've met that standard of care, you are not liable. It's different from qualified immunity, which we'll be talking about in a minute, but that's it in a nutshell. This also applies to officer liability. And again, most board members are also officers, but if you're wearing your officer hat and doing something in your capacity as that officer, whether it be president, vice president, treasurer, secretary, so on and so forth, you are not liable as long as you are acting in your capacity and that exercise was exercised, again, good faith, ordinary care, in a manner the officer reasonably believed to be in the best interest of the corporation. All right, so how do we establish that good faith prong? So three-prong test. How do we establish that first prong, good faith? And to a lesser extent, the second prong, the ordinary care, there's an easy way to do it. If the association, if the board relies on the advice of an expert in making their decision, they've met their good faith prong. And they've more or less met their ordinary care prong as well. But good faith especially, and this is statutorily created, Section 3.102 of the Texas Business Organizations Code. So for community associations, whether you're single family or condominium, who are your experts? An officer or employee of the entity can be an expert. So if you're large enough to have employees and you don't use a third-party management company to offer those employees, or you use them, but you make the decision that you're going to keep them as an employee, that can be an expert. Your attorney, me, I can be an expert. So if I'm giving legal advice, that can be considered expert advice. Your CPA, your investment banker, person who you reasonably believe to possess professional expertise. Committee of the governing authority, which the governing person is not a member. So sometimes committees as well. And then finally, your manager can be an expert in a wide variety of topics. So if you are relying on the advice of that expert in making a decision, then you are more than likely going to meet your good faith prong and your ordinary care prong. So it makes it that much easier for an attorney defending the association in the event of a lawsuit if you've relied on expert advice in decision making. Now, here is the exception. If we can go back a slide. Here's the exception. A volunteer may not rely on the above information, the advice of an expert, if he or she has knowledge that makes the reliance unwarranted. So if you know or should have known that you shouldn't be relying on this expert opinion, well, then you don't get to rely on this statute. So let's use attorneys. This is an easy one. And let's just say I'm your counsel for purposes of this hypothetical. You say, hey, Clint, we want to do X, Y, and Z. Is that okay to do? I look at your governing documents. I'm very familiar with state law. I respond with, board, no, you cannot, and here's why. This is advice coming from an attorney who is double board certified in residential real estate and property owners association law. So I'm a specialty attorney. So you ask me that, I respond with no, and here's why. You don't like that answer. You really, really, really want to do X, Y, and Z. So you go to attorney number 2. This attorney generally practices real estate. She is not board certified in property owners association law or residential real estate. But you ask the question and she more or less comes back with the same answer. No, you can't, and here's why. Again, you don't like that answer. So you go to attorney number 3. This attorney practices all areas of the law. He practices civil, criminal, family, you name it, he does it. You ask him that question and he comes back with, well, sure, board, I don't see a problem with that. Go for it. You rely on that third opinion and you do X, Y, and Z, you get sued for it. In that particular instance, you more than likely are not going to get to rely on 3.102. Why? Because you have reason to believe your reliance on that third opinion is unwarranted. Why? Because you got 2 previous opinions beforehand. So again, many times it is okay to get a second opinion from a variety of experts, but be careful what you ask for. All right, so what is ordinary care? So good faith, if we rely on expert advice, we can meet it. Ordinary care means that degree of care that would be used by a person of ordinary prudence under the same or similar circumstances. So somebody very much like you, what would they do? And if the answer is they would do more or less what you did, then you've met your ordinary care prong. Okay, so we've talked about the general standard of care. So good faith, ordinary care, and reasonableness. The next standard of care we've got to talk about is that of a fiduciary. And the Texas Uniform Condominium Act imposes on an officer or a member of the board a duty of a fiduciary of the unit owners for such officers or board members' acts or omissions. So you owe a fiduciary duty to the owners and to the association. Now, the unique thing to remember for fiduciary duty is that it does not apply to condominiums who were created, whose declaration was filed before January 1st of 1994. So, good faith, ordinary care, and reasonableness standard is a much lower standard than fiduciary duty. Fiduciary duty applies to communities that are condos whose declaration was recorded on or after January 1st of 1994, on or after 1/1/94, or the condo adopted all aspects of TUCA. Or here's the other exception. So we've got condominiums after 1/1/94 that have a fiduciary duty. We have condominiums that have adopted all aspects of TUCA. They have a fiduciary duty. And then the third type of community can be a condo or a single family. And it is when the governing documents impose on the board a fiduciary duty. So those are the 3 times that fiduciary duty is created as the standard of care for boards. If you're not one of those 3 situations, so if you are a condominium whose declaration was recorded before January 1st of 1994, your standard of care is good faith, is that 3-pronged standard that I just went over. If you are a townhome community that has lot ownership, so you're not a condo townhome, you are more like a single family townhome community, then your standard of care is that of good faith, ordinary care, and reasonableness. And then finally, same thing for single family communities, good faith, ordinary care, and reasonableness. So those are the 2 standards. Fiduciary duty, it is owed to the member, and it's owed to the entity and the officers and directors. So that is the fiduciary. Now, what is a fiduciary duty? It is that of a trustee. So think of yourself, if you were a board member in a condominium regime whose declaration was recorded on or after January 1st of 1994, think of yourself as a trustee of a trust, and you've got your beneficiaries, your members that you have to look out for. That means you have to wisely spend the funds in accordance with the trust documents. You have to retain some sort of an expert that helps you invest the money wisely. You've got to figure out what to budget for. So those types of standards apply to you as a board member. So you've got to spend your funds wisely. You've got to develop a good budget that's based on, historical data and the advice of your manager or other expert if you need an expert. Maybe it should be based on what? A reserve study. Maybe that's going to help you meet your duty, your fiduciary duty to your members. If you have a good reserve study you're hanging your hat on to establish budget. And then you've got to do repairs that are required by the governing documents. And there's a litany of other things you've got to do as a fiduciary, but just keep in mind that fiduciary duty is a heightened standard. Oh, and I forgot to mention, if you have any questions while we're going through this, please type them in. I'm happy to answer them as we move through this presentation. So that is our standard of care. In summary, we've got single family communities, townhome communities where you own the lot, and condos whose condo declaration was recorded before January 1st of 1994. Those three, your standard of care is ordinary or good faith, ordinary care in a manner you reasonably believe to be in the best interest of your community. Condominiums whose declaration was recorded on or after 1/1/94, or who have adopted all aspects of TUCA, or whose declaration says otherwise, those communities have a fiduciary duty. So those board members owe a fiduciary duty to its members and to the association. So that's our standard of care. Let's get into some liability, or let's get into some immunity. There are two immunity statutes we're going to be talking about here today. One is the state version. It's the Texas Charitable Immunity and Liability Act of 1987. And then we're also going to be dealing with the Federal Volunteer Protection Act. So let's get into the Texas Act first. It is Chapter 84 of the Texas Civil Practice and Remedies Code, and it protects directors from third party or non-member. So not an owner suing the association and the board, but from third party lawsuits and challenges. And it also potentially caps your damages against employees and the organization. So if somebody sues you, there's only so much money they can get out of the association. It caps that amount as long as certain requirements are met. So volunteers of charitable organizations are immune from civil liability for acts or omissions resulting in death, damage, or injury, as long as the volunteer was acting within the course and scope of his or her duties or functions within the organization. It doesn't apply to the association. It only applies to the board, but the association gets to enjoy certain caps. So how do you ensure that you are making actions or taking actions, making decisions within the course and scope of your powers and duties as a board member? So let's get into this a little bit. I'll do a sidebar here. Picture kind of a bubble surrounding you as a board member. As long as you stay within that bubble, this third party can't attack you, cannot go after you personally, can't attack your personal assets. You are immune from lawsuit because you're within that bubble, so they can't pop the bubble or pierce the veil. As long as you are staying within that bubble. What is within that bubble? Within the bubble are all of your powers that you can use to decision make, and all of your duties that you have to do in terms of decision making and managing the community. So a power. First thing you should do is get a piece of paper, do a column down the middle. One column will be your power column. The other column will be your duty column. A power is something a board member can do, but is not obligated to do. It's prefaced by the words may, has the power to, can, but is not obligated to, and then whatever the action is. that is something you're not obligated to do. It's something you can utilize in your day-to-day affairs, but you don't have to do it. On the other side of the column is your duties. A duty is prefaced by the words has the duty to, shall, must, and then whatever the duty is. Those are actions that you must take. No ifs, ands, or buts. You as a board have to do it. If you don't, that can get you in trouble. So you've got your power column and your duty column. The next thing you've got to do is, and wait for it, this is really exciting stuff, is get all of your governing documents, whether you're on your computer or you print a fat stack of documents out, and you get to read through them. As you're reading through them, keep in the back of your head that you're looking for powers with those words that I just mentioned, and you're looking for duties. Every time you see a power, write it down. Make a reference to where you're pulling it from. Article 3, Section 9 of the Declaration, or the bylaws, or the Articles of Incorporation, and then whatever the power is. Duties, same thing. Once you've gotten your list, those are your bubble actions. So if you're taking actions based on a power or a duty, you're staying within that bubble. There's some exceptions we'll talk about here in a minute, but that is the easiest way to stay within the bubble. Now, what if you want to do something that is not a power or duty? You can't find it anywhere. Well, what you need to do is you need to get with your management company, and your manager, he or she, may be able to answer the question off the bat and say, yeah, you can do that, and here's why. Or they may say, no, absolutely not, and here's why. If the manager's unsure, the next step is ask your legal counsel, right? Ask your attorney. Have them take a look at it. And the attorney's going to review your governing documents, number one. Maybe they can find something that you missed. Or they're going to know state law. They're going to know the Texas Property Code and the Texas Business Organizations Code, and potentially some other codes like the Texas Occupations Code as it relates to towing. And they'll be able to tell you whether or not it is something the board can or cannot do. And they'll give you a legal basis for that. So that's how you stay within that bubble. All right, so definitions: a homeowners association or a POA are included in the definition of charitable organization. A volunteer is acting in their course and scope. They cannot receive compensation in excess for reimbursement for expenses. So that's why it's so important that you as a volunteer do not get paid. Because if you get paid, you do not get to enjoy the bubble of protection. No bubble for you. Is it really worth getting paid a little bit to lose that immunity protection? Putting my attorney hat on, I think the answer is no. It's just not worth that personal liability risk. Now, again, the caveat is if it's a reimbursable, if it's something that you spent money on and you're seeking reimbursement, that is okay. That is not compensation. And also, if you're offering a service to the association, let's say you're a contractor and you're providing some service to the association, but you're also on the board, that may not pull you out of the Texas Charitable Immunity and Liability Act, but there are some additional statutory requirements you've got to comply with if you are going to do that. And again, good faith, what is it? It's the honest, conscientious pursuit of activities and purposes that the organization is organized and operated to provide. That's where your powers and duties come from. Does not apply. Here's an exception. So even though you're trying to argue it's a power or duty, well, it doesn't apply to an act that is intentional, willful, or wantonly negligent, or done with conscious indifference or reckless disregard for the safety of others. So we're talking more or less about intentional torts here. So getting into a fight with an owner at a board meeting, physically, or assaulting somebody, or engaging in sexual assault, the list goes on and on. Things that would make a normal person go, I don't know that that'd be covered. It's not, right? So, keep your cool as much as you can at your board meetings. I know sometimes it can be a little stressful and frustrating when you have 50 people yelling at you and saying you're not doing anything right. even though you're doing it all for volunteerism, kind of out of the goodness of your heart to better the community. It's tough, but keep that in mind. I'm not suggesting anybody on the phone would ever do it. Again, we've got to keep in mind that this does not modify the duties or liabilities of a director or the officers to the organization or its members and shareholders. You still have that standard of care obligation you've got to meet. Okay, here is the insurance limits. So in order to enjoy this Immunity and Liability Act, you have to have certain coverage limits in place. More than likely, every board member who is on the phone here right now has insurance with these limits. If you're unsure, speak with your manager. If you're self-managed, speak with your broker. He or she is going to be able to get you the information you need. But I will say these are fairly low, all things considered. So you should be able to get these minimums. If you don't have proper insurance, get it as soon as possible, because you want to make sure you're protected and you get to enjoy that liability cap and that immunity protection. All right, so that is the state act, the Texas Charitable and Immunity Act of 1987. So let's get into the federal act, the Volunteer Protection Act of 1997. It's uniform, provided to volunteers and nonprofit organizations in lawsuits based on the activities of the volunteers, right? The board members and potentially the committee members. And it only preempts state law that provides less protection than the federal law. And it allows for states to opt out if they so choose, but no state has done so yet. Very similar wording to the state act. Volunteers of a nonprofit are not liable for harm caused by an act or omission of the volunteer on behalf of the organization if the volunteer was acting within the scope of their responsibilities and the harm was not caused by, again, willful or criminal misconduct, gross negligence, reckless misconduct, or a conscious flagrant indifference to the rights or safety of the individual harmed by the volunteer. So again, don't engage in that at the board meeting. No immunity in suits by the nonprofit organization against its volunteers. So if an association decides to go after its board member or members, there is no immunity protection. But here's the caveat. If an association decides to go after an old board of directors, your insurance may kick in and defend those old board members because they were, they basically committed the acts while they were board members, and there was insurance in place at that time. So again, insurance may deny coverage because the act was so heinous or horrible, but keep that in the back of your head. If you're an association wanting to go after a prior board member or board members, you really need to get with your manager, if you've got one, and your legal counsel to talk about all the pitfalls to think about. And most of the time, it really is not a good idea. And it does not provide immunity to the organization. Again, similar to the Texas Act, no immunity for the organization. Punitive damages. It also protects board members and other volunteers from punitive damages as long as the volunteer was acting in the scope of their responsibilities, right? Staying within that bubble, only using the powers and duties within that bubble based on governing documents or state or federal law. To succeed in punitive damages. So in order for a claimant to go after an association volunteer for punitives, they have to prove by clear and convincing evidence, that's a higher standard they have to meet, that the volunteer's action constitutes willful or criminal misconduct or a conscious flagrant indifference to the rights or safety of the individual harmed. If they prove that, then they can get punitive damages. Here are some exceptions for the federal law. if what you did, if the action of the volunteer constitutes a crime of violence or an act of terrorism, a hate crime, sexual offense, violates state or federal civil rights law, or where the defendant was under intoxication of alcohol or drugs. That last one I've had to deal with. So, you're a board member, you work, you've got to provide for the family most of the time, and you've had a rough day at work. And I don't want to deal with a 4-hour board meeting tonight, but I need to. I'm the acting president. So you go home before the board meeting and you make yourself a cocktail. I get it. People have long days sometimes. You go to the board meeting, you have your cocktails, and you make decisions while you're enjoying that cocktail. Well, if it is found out that you did that and you get sued on the actions that you took while enjoying that cocktail, you may not get any volunteer immunity protection, number one. Number two, you may not get any insurance coverage. So do not enjoy the cocktail until after your board meeting. No decision making under the influence of alcohol or drugs. On violating state or federal civil rights law, this is another interesting one that we can run into occasionally. So let's assume that we've got a pool. So you're in a community, the association has a pool they manage, and you've got some signage out there in front of your pool. And one of the rules that owners and residents and guests have to comply with is that any person who is under the age of 18 has to be accompanied by an adult. That's the rule. Hopefully nobody on this call has that rule in place, but let's assume one of you do. And you've got a owner with a child who is 16 years old. So the purpose of the rule is what? Well, the stated purpose is more than likely to provide for safety. Hey, we're dealing with minors. We need to be safe with them, so let's have an adult on property as well. What if there was a resident or an owner who has a child that's 17 that is also a lifeguard, has been certified by the Red Cross, lifeguards at pools, and literally can save lives on a daily basis? Under that rule, you are saying that that person who probably swims better than 95% of your community cannot use the pool unless their mom, dad, or guardian are present. Well, the federal courts out in California found that that was not a connection. So there was no reasonable nexus between the stated purpose of the rule and its effect. Why? Because you can have 17, 16, I think 15-year-olds who are certified by Red Cross to enter bodies of water and save lives. So because there's no relationship, the association was found to have discriminated on the basis of familial status. So the family status, the minor idea. Because of that, they violated federal law. So again, got to be wary about that. So make sure your pool rules are up to date, because if you don't have it, you don't get to enjoy the Federal Volunteer Protection Act. Why? Because you have violated federal law or federal civil rights law. Okay, so let's get back into our standards of care. Again, we've got the one standard of care, good faith, ordinary care, and reasonableness. We have the other standard of care, that of a fiduciary. And we've already gone into which applies to which. Hopefully y'all took good notes and know where you stand. There are two ways that a court is going to look at that to see if you've met your standard of care. Way number one is what is called the business judgment rule. And way number two is called the reasonableness standard. And in Syntec v. Siegler, Texas Supreme Court case in '95, the court basically found that similarities between associations and corporations has led to the conclusion that an association is a separate legal entity from its owners, just as a corporation is distinct from its shareholders. So they're going to use these standards in looking at decision-making by the board. Let's start with the business judgment rule or the business judgment standard. This is the more favorable of the two standards. And it's as a general rule, courts will not review the decisions of community associations directors if they act in compliance with the prescribed standard of care and they analyze the process the directors took to make the decision. They do not look at the results. They're not doing the Monday morning quarterback or the hindsight is 2020. It doesn't foreclose a judicial review of the director's decisions. So it looks at the process. The court can still look at the decision as well. It just gives the director a little bit more breathing room to make those decisions. There's not as much Monday morning quarterbacking under the business judgment standard, and that's why it is a little bit more favored. The reasonableness standard. The burden is typically placed on the association and the board to prove their actions resulted reasonably. And unfortunately, the court imposes their belief as to what is reasonable, or the jury to determine what is reasonable. And it's based on the outcome of the decision, that Monday morning quarterback. And the process of decision making is not really under scrutiny. So it's kind of a second guess standard of care, and that's why, or second guess standard. That's why it is not as favored. Okay, let's take a look. Bavel v. Oasis Design, Texas Appellate Court, Austin, 1998. And it basically just talks a little bit about more what we just discussed. A director, if it falls within the protection of the business judgment rule, and basically conduct that is merely unwise, inexpedient, or imprudent will not sustain suit against management of a corporation by its shareholders. Again, looking at the process, not at the decision made and whether or not it was reasonable. To invoke it, a director must be informed of all the material information. So you've got to have all that information available to you before you make your decision. That's why it's important to get the multiple bids, right? That's why it's important to get the advice of an expert, whether it be legal counsel or a CPA or otherwise. And basically the information you considered, the use of experts, the notice given to the board, and then the board's independence. If the board was informed, their conduct falls within the protection of that business judgment rule. Texas Property Code is something else we get to rely on, 202.004. The decision making of the board gets a presumption of reasonableness. So every decision you make as a board member is presumed reasonable unless the court determines by a preponderance of the evidence that your decision or your exercise of that discretionary authority was arbitrary, capricious, or discriminatory. Arbitrary, capricious, or discriminatory. So what is arbitrary? What is capricious? Discrimination, y'all are familiar with that term of art. Discriminating based on gender, nationality, age, race, all that stuff. Those are protected classes. Familial status is another protected class. But arbitrary and capricious, let's go through an example. So we live in a 100-home community, and we're a no RV community, and we've got 7 RVs in the community. And they've been there for, 2 years. Well, one RV is right next to the board president's home, and that is the only RV that the board decides to go after and seek enforcement on. That doesn't sound very consistent, does it? That may be arbitrary or capricious. Why? Because you are not being consistent in your enforcement of your restrictions. That's why it is so important to follow a set of rules and guidelines for enforcing your restrictions and collecting your assessments and other amounts due and owing. Be consistent, because if you're not, there is an owner who is going to argue that you are picking on them, and here's why. The integrity of the process. So again, consistent. Follow your process established in your dedicatory instruments. Follow that collection policy process or your deed restriction enforcement process. Powers and purposes, we've already gone through that. And as long as you're acting within the powers and duties, court will recognize a presumption of good faith. which is good for y'all. So be consistent, follow your rules and regs, make sure it's a power you've got to exercise. And if all of that has been met, then you get to rely on that presumption of a presumption that what you did is reasonable. Okay, let's see. It looks like we may have a couple questions popping up here. One, if the board vote to take the action is not unanimous, could it be argued that not all people feel the action is reasonable? So I think that's a very good question, but I think as long as it is informed and you've done your homework, you've gotten your expert opinion if you need it, and 3 of the 5 vote in favor and 2 vote against, you've met your standard. You've met your standard of care. You're in good shape there. And again, relying on the advice of your experts. Next question, drugs. Does that mean illegal drugs or prescribed or over-the-counter drugs that might be labeled do not operate machinery? That's another really good question. And, it really does depend on the circumstance. If you're taking some sort of prescription drug that would not allow you to operate machinery, there's a good chance that it may affect your ability to properly decision make. So be careful about that. Can an association use the regulations to ask that adults accompany anyone under blank age, but make exceptions in the case of a teen who provides documentation they should be considered differently? I do not recommend going down that path. Procedurally, that would be very difficult to implement. I think if you want to put an age in there, you should look at maybe under 14. That may be linked a little bit more closely to a safety standard, but I just adopting those types of rules are just going to be very difficult to enforce. Because we had no one running against the incumbent in an election, the board chose not to have the election as Texas Property Owners Association allows. A temporary restraining order was filed, business judgment standard or reasonableness standard, or neither. Boy, oh boy. I'm going to treat this as a hypothetical. More than likely, the reasonableness standard is going to be employed. Why? Because to really use that business judgment standard, more than likely, you're going to have something in your governing documents that say the business judgment rule is applied. And, a second little issue or point I'd like to make, and maybe your defense attorney is already aware of this, but let's assume that you're a single family community, you're not a condominium. There is a section in 209 that basically says if the number of candidates equals the number of positions available, you don't have to have a vote. A vote is not required. So if you have 2 positions open and 2 candidates, you don't have to have a vote. And that's supported in Chapter 209 of the Texas Property Code. Again, that is assuming you are not a condominium. What liability does a manager or management company have for the decisions and actions of the board if we advise them against acting on or in a particular matter? Good question. And again, I recommend covering yourself. So if you are if you're giving advice that they're going to ignore and they're going to act anyways, make sure you have that advice papered. Get legal counsel involved or a CPA involved or other expert, depending on what the issue is, so that expert, he or she, can give something supporting management company's opinion that this should not be done. And if they act anyways, if it's egregious enough, I've got some management companies who decide to terminate the relationship. So it's not a good situation to be in, but hopefully you can steer the board in the right direction before they make that decision. Another question, what is the best practice of dealing with HOAs that want to allow homeowner volunteers to do landscaping improvements on common areas? Is workers' compensation insurance sufficient? So good question. You do need to have proper insurance involved. You probably want to get them to execute some sort of a waiver. so that they acknowledge that, look, they're doing this merely as a volunteer, and if they get injured doing it, they're not going to seek any kind of recompense or damages from the association. What do you do if there's an election and no candidates? Those stink, especially right now. So pre-COVID, I would say have the annual meeting and really push for a nomination from the floor. But with COVID-19 in full force across most of the state, in-person meetings are either prohibited or very impossible to effectively have. So you've got to do it virtually. How do you do nominations from the floor virtually? It's a difficult problem. There are some options and ways to go about it, but it really is dependent on your governing documents. So if you're dealing with that right now, it's probably a good idea to reach out to your manager if you have one, and or your legal counsel to discuss some of those options. If not a board member and we have volunteers to, say, spread the mulch at the playground, are they covered as volunteers? It would depend on how your insurance policy is written, but regardless, if you've got volunteers wanting to go out and do manual labor, which I get it, I understand, I recommend that you get them to sign a waiver so that they agree that if they get injured out there, they're not going to pursue any kind of damages or litigation against the association. So for condominiums, we did some single family reasonableness. For condominiums, reasonableness is measured in the context of kind of condominium living. So, boards really should be given some discretion in how they make decisions on which units to perform maintenance on and which units not to perform maintenance on. And as long as you're not being arbitrary and capricious in that maintenance and you're following a process, then that decision making should be okay. Keep in mind that don't do your units first. You've got 10 units and 5 of the units are board member units, and those 5 get done first. That does not look good on paper, even though procedurally it may have been sound. The other thing to think about is if you've got an obligation to maintain certain common elements and common areas and the units, and you fail to do so because you do not have funding, there are cases out there that indicated you've got to keep trying to get that special assessment passed. You've got to keep trying to increase your regular assessments or obtain a loan from a bank. You don't do it once and then just give up. Keep going, keep trying, because there is an obligation on the part of the board to adequately maintain those areas. Here are a couple more cases. And they're here. I'm not going to go into them. Frey v. Day, Cordova, Texas Supreme Court out of 83. Not going to interfere with an association's right of internal management, so long as the governing body does not substitute legislation for interpretation or overstep bounds of reason, common sense, or fairness. Just some subjective terms that courts look at. Here's kind of a definition of what unreasonable is. Again, unreasonable is defined as not conformable to reason, irrational, not governed or influenced by reason, beyond the bounds of reason or moderation, immoderate, exorbitant. So all very subjective terms, just something that's not reasonable. So before we get into questions, remember, we've got our standards of care, we've got our good faith, ordinary care, reasonableness, we have our fiduciary duty standard. Those 2 standards, depending on the type of community you are. We've got immunity protections as well, both on the state level and the federal level. We have damage caps for the association on the state level as well, as long as you've got adequate insurance in place. Review your documents for your powers and duties, right? You've got to really remember to stay inside that bubble. How do you do that? You understand your powers and duties, and you just use those to decision make. Don't overstep your bounds. And rely on experts when you're making a big decision. I really think that's going to help you. It's going to give you a peace of mind, and statutorily, it offers you some more protection. And then finally, we've already hit this, when and when not there is a fiduciary duty. Again, we're dealing mainly with condominiums there. Got a couple more questions, and we have some time, which is good. Another question: is it not true a volunteer worker would not be covered under a workers' compensation policy as they are not employees? I think that's a very good question, and more than likely you are correct for workers' compensation purposes, because they're not an employee. And you don't necessarily have to be an employee. There are ways to have coverage in the event a independent contractor's employees gets injured on property and the independent contractor doesn't have workers' compensation. Speak with your insurance broker and about those options. One is kind of a waiver that the contractor signs to get out of workers' comp. Another is some insurance coverage that protects you and kind of activates workers' comp in the event somebody gets injured on your property. So look at those. Speak with your manager, speak with your insurance broker about options. Would a homeowner volunteer also be protected by charitable immunity? Maybe. Yeah, maybe. I would prefer that they were committee members or board members, but if you're dealing with somebody who's doing work on property, would they be covered? Maybe. It's a little unclear. If you're looking to do something big where there's some significant liability potential, get with your legal counsel. It may be wise to establish what's called an ad hoc committee, appoint committee members, and then ensure the insurance covers those committee members for purposes of your liability protection and directors and officers. You mentioned damage caps. What are they? I think it's a $1 million cap, and then there's some other statutory caps. It's one of the previous slides, but those caps are in place, and more than likely they'll be applicable as long as you meet certain insurance requirements. If you want to shoot me an email, I can send you the correct statutory provision that establishes those damage caps. Another question. Board called a special meeting to elect an officer. This is another hypothetical. And during the meeting, board members had connection issues and did not hear the whole meeting. Comments were made a few times during the meeting. Board members are having issues connecting. A vote was taken by those more board meetings that could hear, and the officer was elected to fill a vacancy. Boy, oh boy, that sounds like a bad situation to be in. I recommend you get an attorney opinion on that or a manager opinion on that, because that is not a good situation to be in. I would have a couple additional questions to ask as well in terms of the connectivity. What was it a result of software malfunction, or is it merely that one board member who lost connectivity? If the board members that were attending and then lost connectivity, did you still have a quorum when connectivity was lost? If you lost quorum, can you really take action when you're lacking that? Is quorum dictated by your ability to hear and be heard on a virtual meeting? All very, very good questions to ask on that particular issue, but that is definitely an attorney opinion type scenario. So reach out to your attorney, get an opinion on that one, because it is not the best spot to be in for a virtual meeting. And it sounds like you can probably appreciate that because you're asking the question. Did I understand correctly? The board members have a fiduciary duty with regard to the finances of the association. So if the board is not following a 4 to 5 year old capital reserve study, do they have a fiduciary responsibility to follow? So first and foremost, what kind of association are you? If you are a condominium whose declaration was recorded on or after 1/1/94, or a condo who's adopted TUCA, or your governing documents say so, that you have a fiduciary duty, then yes, you have a fiduciary duty. If, however, you are a single family community or a townhome community with lots, or a condominium whose declaration was recorded prior to 1/1/94, then you do not owe a fiduciary duty. You've got the good faith, ordinary care, and reasonableness standard. Reserve studies are important to get updated and are important to rely upon in helping to establish your budget. It helps you to establish your standard of care because you are relying on the advice of an expert in doing what? In decision making, in establishing the budget for the following year. So, that reserve study may be a little outdated. It may be time to get a little update. And from what I understand, if you use the same reserve company you used the first time, you get a bit of a discount. So it's not the same price that you paid the first time you obtained the reserve study. But definitely a good idea to get that done. Okay, I think that's it, and we are out of time. Thank you all so much for being with us here today. Again, as a reminder, if you called in, email your name and phone number, pretty please, and let us know if you need that education credit. For those of you that have requested the credit, expect your documentation here in about a week. Again, thank you all for coming. Clint Brown with Roberts Markel, and I hope you enjoy the rest of the day. Stay warm and enjoy the rest of your week as well.